Good afternoon and welcome to today's webinar, Housing, Law, and the Impact on Domestic Violence Survivors, brought to you by the Network for Public Health Law and the American Society of Law, Medicine, and Ethics. I'm Charles Strong, the Digital Marketing Coordinator at the Network for Public Health Law's National Office, and I'll be your host for today's webinar. Please feel free to submit questions at any time during this webinar by using the Q&A tab on the right-hand side of your screen. All you need to do is click on that tab, select all panelists from the Ask drop-down menu, and submit your questions. If you do not see the Q&A tab available, click on the button with 3 dots as shown in this picture, and that will give you access to the tab. Your moderator for today's webinar is Mathew Swinburne. Matt is the Associate Director of the Network for Public Health Law's Eastern Region Office. He provides legal assistance to state and local legislators, health officials, and non-government organizations. Matt's current work focuses on food insecurity, injury prevention, medical cannabis regulation, environmental health, telehealth, and health equity. Matt will be leading us through the rest of today's webinar, so Matt, over to you.
Good afternoon. I want to thank everyone for joining us today for this important webinar. We have a great group of panelists today who have a lot of really interesting and important information to share with the group. I'm going to start off by introducing the 3 panelists we have gathered here today. Our first panelist is Sasha Sandburg Champion, and he is of counsel at Relman, Dane, Colfax, where he practices in the civil rights litigation. He has argued dozens of appeals and has played a role in briefing and arguing many more cases, raising novel and important civil rights questions before trial courts, the Court of Appeals, and the U.S. Supreme Court. He previously was a senior attorney at the Appellate Division of the Justice Department's Civil Rights Division and Assistant Solicitor General with the New York State Office of the Attorney General. He is a graduate of Columbia Law School and the former law clerk of the Honorable Jed S. Rakoff of the U.S. District Court of the Southern District of New York, and for the Honorable Robert A. Katzman of the U.S. Court of Appeals for the Second Circuit. Today, Sasha will be discussing local nuisance ordinances that are being used to compromise the housing rights of domestic violence survivors and some of the litigation surrounding these laws. Our second panelist who will be speaking is Katie Moran Mccabe, and she is a law and policy analyst with the Center for Public Health Law Research. Katie has been closely involved with the creation of data sets regarding nuisance property ordinances, office-based surgery, and school discipline laws. She also conducts research on a variety of housing issues for the Legal Levers for Health Equity Through Housing Project. Prior to joining CPHLR, Ms. Moran Mccabe worked as the Director of Enforcement with the Fair Housing Rights Center in southeastern Pennsylvania, where she advocated for victims of housing discrimination. Ms. Moran Mccabe graduated from the University of Delaware with a bachelor's degree in business administration and earned her JD degree from Temple University's Beasley School of Law. Her areas of interest include public health law generally and housing law in particular. Today, she will be discussing policy surveillance completed by the Center for Public Health Law Research, which focuses on local nuisance ordinances, state landlord-tenant protections, and state fair housing laws. Our third panelist is Rasheeda Phillips, Esquire, and she's the managing attorney for the housing unit at Community Legal Services of Philadelphia, which provides legal advice and representation to tenants facing eviction and other housing loss, as well as local, state, and national systemic advocacy on homelessness prevention and the preservation of affordable housing. She began her career at CLS in 2008 as a Pennsylvania Legal Aid Network Martin Luther King Jr. Fellow in the Community Economic Development Unit, providing legal advice, representation, and resources to low-income child care businesses and nonprofit community organizations. Rasheeda is a 2008 graduate of Temple University's Beasley School of Law and a 2005 summa cum laude graduate of Temple University with a degree in criminal justice. Rasheeda will be discussing the Violence Against Women Act and the protections it provides in regards to public housing, as well as some strategy for housing advocates. Now, before I hand over the microphone, so to speak, to our panelists, I want to provide some public health context for the issues we're discussing today. You know, why is this a public health issue? Why is this a public health law issue? And so I'm going to provide a little bit of scope and briefly discuss the public health implications of the underlying issues that we'll be discussing. So before we get into that, I want to just go over two important terms. We'll be using the term domestic violence a lot, and this is a term that includes physical, sexual, emotional, and economic abuse, as well as stalking and controlling behaviors committed by intimate partners, immediate family members, and other relatives. Now, the other key term I want to kind of just define is this concept of intimate partner violence, which is really a subset of domestic violence that really focuses on violence perpetrated by a current or former intimate partner. Now, I wanted to make sure that kind of have a basic understanding of those terms, because when looking at the scope of this issue in the United States, both of these terms are used. So domestic violence really is an immense public health challenge in the United States. If we look at some of these statistics, 36.4% of women experience contact sexual violence, physical violence, or stalking by an intimate partner, and that comes out to around 43.6 million women in our country. Going down this list that you can see on the slide, there are a lot of startling and disturbing statistics related to this. You know, domestic violence accounts for 21% of violent crime. Half of all female homicide victims are killed by intimate partners. So this really is an issue that I think a lot of people don't understand how large of an issue or the scope of the issue in the United States. Now, beyond what we often associate with discussions of domestic violence in terms of, you know, the kind of the physical injury, there are a lot of other health problems that are associated with this. And this is just a list of some of the other health conditions that are associated with domestic violence, ranging from asthma to depression, sleep disturbances, migraines, circulatory conditions. There's a wide range of serious health issues that survivors of domestic violence are exposed to because of the domestic violence. Now, we're talking about housing rights. Why are we talking about housing rights in terms of this issue of domestic violence? Well, domestic violence is one of the major causes of homelessness in our country. And one study showed that 15% of homeless individuals are survivors of domestic violence. Another study showed that it's the fourth leading cause of homelessness in families with children. And this is because individuals, when they're leaving their abuser, often don't have a lot of safe housing options because of limited resources or because of the nature of the abuse, where they were economically and socially isolated by their abuser. Now, from a public health standpoint, this just exacerbates the concerns we had before, because homelessness is associated with a lot of other health challenges, ranging from difficulty accessing health care to substance abuse, sexually transmitted diseases, and it has a huge impact on the mortality rate of individuals who are experiencing homelessness. So it's kind of a public health imperative to look at the housing rights of DV survivors so that we can act in an upstream manner to cut off some of these negative health implications. So with that kind of context of, you know, why we are discussing these legal issues today of DV survivor housing rights and housing protections, I want folks just to have this in the background of why this is such an important public health issue. Now, that being said, I'm going to pass the microphone to Sasha so that he can begin his presentation.
Thank you, Matt. See if I can do this properly. Okay. So my name is Sasha Sandburg Champion, and I work at the law firm of Relman, Dane, and Colfax, which is a civil rights law firm with a national practice. We particularly do cutting-edge Fair Housing Act issues, and I think you'll soon see why that comes into play. We are engaged right now in a couple major pieces of litigation regarding nuisance ordinances, and I think those are good case studies so that you can see how municipal nuisance ordinances exacerbate the problems that were just described to you. So what are nuisance ordinances? Nuisance ordinances are municipal ordinances that basically, to put it plain and simple, impose consequences on people or properties that are considered to be nuisances. And this is a national movement that began in the 90s. It's closely related to the broken windows theory of policing, and you'll see it overlaps quite closely with the sort of zero tolerance approach. At this point, over 2,000 local governments have some form of them, and I'll show you a couple examples, and you'll see that the form differs from place to place. But they have important similarities. The key is that the local government can either directly or indirectly require the eviction of tenants whose behavior is considered to be a nuisance. So you can see already the path to homelessness that this creates. And nuisance behavior is usually defined as multiple police calls or other contacts rather than the adjudication that a crime has occurred. So the result of this is that city officials, and particularly police departments, end up having great discretion in enforcement because by their actions, they can sort of unilaterally make someone deemed a nuisance with these really troubling consequences. We and others have studied the results of these ordinances, and what we have found is first of all, there's disproportionate enforcement in minority communities. This is very closely related to discriminatory policing practices, and often is an outgrowth of them as applied to housing. We see considerable enforcement against survivors of domestic violence, which I'm about to describe, and other crime victims, and also people with disabilities. There's a very troubling prevalence of applying these against, for example, people who are suicidal or otherwise need frequent ambulance calls. There's no, and I just want to put a pin on all this and note that all this is very intersectional. It's not that it's a racial justice issue or it's a DV issue or it's a disability issue. Oftentimes this is something that affects people who fall into all of these for some reason or another. There's no evidence that any of this furthers any purported safety goals. What it does instead is it makes tenants reluctant to call police because they quickly learn to understand that that's the trigger for enforcement against them is their own calls to the police. So from a public health standpoint, it should be obvious why this is a completely counterproductive way to go. So let me give you one case study, and this is Maplewood, Missouri. And both we and the ACLU have done litigation against Maplewood, which may have the most obviously problematic nuisance ordinance of any we've looked at, just on its face. Maplewood actually requires you to have an occupancy permit from the town to live there. So you actually have to go to the town and secure an occupancy permit, or you can't live there legally. Maplewood has a nuisance ordinance under which it can revoke your occupancy permit once it deems you to be a chronic nuisance. And I put on the screen for you Maplewood actually has about 20 different categories of things that could make you a chronic nuisance. But here's a couple of the definitions that include, so you can see how broad it is and what discretion it gives to the local officials. Anything done to the hurt, injury, annoyance, inconvenience, or damage to the public. And then note one specific example in the statute itself is more than 2 instances within 180 days of peace disturbance or domestic violence resulting in calls to the police. So on its face, it says that you are going to be a nuisance if you have 2 or more calls regarding domestic violence. And the remedy to abate this nuisance is to revoke your occupancy permit, which effectively exiles you from town. Why? So in thinking about why Maplewood would have something like this, I just want to give you some geographic and demographic background. Maplewood is one of the ring towns right outside St. Louis. I put Ferguson on the map too, so you can see where it is for people who have been following events there. And what you can see is whereas Ferguson is in the cluster of northern towns outside St. Louis that have become predominantly African American in recent years, Maplewood is in the just a few minutes south is in a cluster of towns that are still predominantly white. So that might give you some sense of what's going on here. So we did a study in Maplewood along with the local fair housing organization there, the Metropolitan St. Louis Equal Housing and Opportunity Council. And what we found from public records, we studied 43 enforcement hearings over a 5-year period, and that's all that we were able to get our hands on. And we found that most of the majority of the affected households were African American, even though that's only 14% of the population. Over 25% involved residents whose misconduct was mental illness or other disability, for example, the suicidal people I described. And then 37% were domestic disturbances. So 6 of those 43, the nuisance was a clear-cut example of domestic violence, where a female resident was attacked by a male partner, and all 6 women were deemed to be nuisances subject to occupancy permit revocation. And note that all 6 were African Americans. So you can see the intersectional nature of this. It's African American women facing enforcement for incidents of domestic violence. Unfortunately, we sued on behalf of EHOC, the Fair Housing Center, and a federal court didn't think this was enough to state a claim of discriminatory impact or intent. It found that our sample size just wasn't large enough. It's not like we had a statistically significant sample to go on, and it refused to let us go forward, which was very unfortunate. Here's one specific incident in Maplewood, and that's Rosetta Watson, who is the client for the ACLU in their lawsuit against Maplewood. Rosetta Watson was one of those 6 African-American women. She was cited for making 4 calls to the police regarding her boyfriend. I put the details here. I won't go through them, but they're classic domestic violence incidents where she called the police. And Maplewood invoked the nuisance ordinance and revoked her occupancy permit, finding that she was taxing the resources of the Maplewood police force by her frequent calls for help to the police. As a result, now look at the collateral consequences to her. As a result of this action, she also lost her Section 8 voucher because of the non-renewal of her lease. So it wasn't just that she was evicted, it reverberated further in terms of her housing options. As a result, she was homeless for a while. Eventually, she moved to St. Louis, where she faced further abuse but was afraid to call the police. And you can see why. So you can see, as a public health matter, this is working to discourage the reporting of domestic violence, and that can't be what people want to have happen. The ACLU sued on her behalf last year. That case has largely settled. Unfortunately, they were not in a position to require change to Maplewood's law, just because Rosetta Watson is not currently a resident of Maplewood, so she doesn't have standing to seek that. One positive outcome of this is that the publicity surrounding our lawsuit and the ACLU's lawsuit has caused conversations in the town about whether to change the nuisance ordinance, which most citizens did not know was doing this in their name. Let me give you a second case study, and that's Hope Fair Housing Center v. City of Peoria. This is the lawsuit we're doing right now against the City of Peoria, which has a comparable ordinance. The Peoria's ordinance defines a chronic nuisance property as any property where 3 eligible offenses occur within a year, and that, again, it's a wide range of quote-unquote offenses, and again, this is not offenses as adjudicated in a court of law. This is offenses as deemed offenses by the police without any opportunity to challenge that. Indeed, you could have a couple of offenses on file, and you might never even know about it. You don't get notice that an offense has been docketed against you. This statute used to say that assault or battery or any related offense was covered. Now, after we sued them, they amended to say, but not including domestic violence. Whether this actually means anything in the real world, we don't know yet. We're about to enter discovery. We've survived a motion to dismiss in this case, and we're about to have an opportunity to find out what's been happening on the ground there. Here's what we know, though. Once a property is deemed a chronic nuisance ordinance, the property owner is forced to abate the issue, and that almost always means that the city will then force them to push the problematic tenants out. There's almost never a contested eviction where all this can be aired. The tenants just leave, and in large part that's for the reasons that we described with Rosetta Watson, where if you fight this, you're at risk of losing your voucher, and very often that's an issue with these tenants. They'll just leave when this happens to them. As a result of that, we don't have extensive records of the tenants that are affected. What we do have is records about which properties receive nuisance designations, including those properties where that happen in part on domestic violence. Here's what we found when we studied that pattern of enforcement. I put up on your screen a map of Peoria, and the blue shaded areas down at the bottom, as they get darker, are areas in which it's more predominantly African American neighborhoods. And those dots are nuisance enforcement incidents. So I think once people see that map, it's very clear that this is a type of enforcement action that's basically only occurring in predominantly African American parts of town. And this is part of it. I remember that I connected this to discriminatory and overly aggressive policing practices, and the city of Peoria actually has two of these armored vehicles, which they call armadillos, that are labeled nuisance abatement vehicles, and they will literally drive these vehicles out to these various neighborhoods. And these vehicles have video cameras, and they can just be left there remotely to send a live feed of properties that have been designated nuisances to City Hall. So it amounts to a rather draconian and indeed harassing enforcement scheme, and which has severe consequences for survivors of domestic violence, in addition to based on race. So these are the only places in which, as far as we know, there have been these sorts of systemic lawsuits against municipalities. But remember, I told you at the beginning that there's over 2,000 of these ordinances around the country. And every time these ordinances are studied, people find roughly the same results. So these are not one-off results. And I put up on your screen 3 of the more comprehensive studies. One was done by Matt Desmond before he became famous for Evicted. He studied the nuisance enforcement in Milwaukee, and he found that, just as we did, he found that enforcement was disproportionately in black neighborhoods, and he also found that nearly a third of those citations were generated at least in part by incidents of domestic violence. And that as a result, one of the things that landlords did was they would actively discourage tenants from calling 911. So once again, you can see that the outcome of this is completely counter to what you would want to do if your object is to combat domestic violence. What actually Matt Desmond, after writing this, after doing this research, has labeled, he also, like us, he connects this to broader discriminatory police practices, and he labels it black men locked up, black women locked out. And that essentially is the consequence of enforcing in this manner. I put up 2 other studies that have found similar results. One is in Ohio, where they found more than half the enforcement letters were responses to incidents of domestic violence. And again, it's disproportionately against people using housing vouchers and people of color. And then Gretchen Arnold has done some studies in St. Louis, which are not statistical in nature, but are qualitative, where she interviews many of the people affected, and in terms of the outcomes for them. And she finds that just as Ms. Watson did, they struggle to get housing afterwards, in part because they lose their vouchers and other supports, and then they're discouraged from calling 911, and they become more vulnerable to violence as a consequence of what happened to them. So as a lawyer, we think about what we can do about this, and these are the claims that people have bandied about with differing degrees of success. One is Fair Housing Act claims, and that's what we brought in Maplewood, and that's what we're bringing now in Peoria, to show discrimination on the basis of sex, race, or disability. Under the Fair Housing Act, you can bring these claims in two different ways. You can either say there was an intent to discriminate, and in Peoria we're saying that because we believe they're intentionally choosing neighborhoods based on race, or you can try to show that there is a discriminatory effect, which is what we tried to do in Maplewood, but unfortunately we're had a judge reject us on the basis that we just didn't have a statistically significant sample to go on. Now, the second group is these individual constitutional claims, and this is what the ACLU has used to very good effect. And they've claimed that this is a violation in particular of your First Amendment right to free speech, because you are effectively being penalized for seeking redress from the government, for calling on your government for help. Their argument is that should never lead to a penalty against you, as these ordinances do. And that has been very successful, actually. Here's three of their cases. One that received a great deal of notoriety, Brigs V Norristown, where they ultimately got the ordinance repealed after suing there. Again, that's an African American woman who was a survivor of domestic violence and had the enforcement against her because she called the police. Similar story in their case against Surprise, Arizona, and then the Watson case that they're doing now. And here's a couple. You can see that they actually have some more cases going on right now. I've put in your materials here resources that include the ACLU's webpage on this. And then the Shriver Center out of Chicago has some very good materials regarding crime-free rental housing and nuisance property ordinances. They're actually our co-counsels in our lawsuit against Peoria. They're very knowledgeable about this. Last thing to note is that at the end of the Obama administration, HUD's Office of General Counsel issued guidance to all HUD to local jurisdictions, which are under HUD's jurisdiction for the most part, giving them guidance on application of Fair Housing Act standards to this enforcement of these ordinances. And HUD basically put them on notice that this could constitute a violation of the Fair Housing Act to enforce nuisance ordinances in the discriminatory ways that I've just described. Now, whether that is going to be worth anything during the Trump administration, it's hard to know. Our understanding is that HUD continues to pursue this to the extent that you can prove it's intentional discrimination. But this administration has ideological issues with the disparate impact doctrine, and therefore they're very unlikely to bring enforcement action based on a theory that it has a disparate impact, though unintended, on certain protected classes. And with that, I'm going to turn this over to Katie.
Okay, thank you, Sasha. See if I've got this here. Thanks very much, Sasha, and thank you for providing us with that great information about nuisance ordinances. So I am going to continue that discussion in my presentation by talking about a legal data set on nuisance ordinances and a couple of others that we created at the Center for Public Health Law Research. So at the center, we have used policy surveillance methods to track some housing-related laws But before I talk about these laws and the impacts that they might have on domestic violence survivors, I first want to give some quick background on what policy surveillance is. So policy surveillance is the systematic collection, analysis, interpretation, and dissemination of laws and policies across jurisdictions or institutions and over time. So through policy surveillance, we analyze the contents of laws and policies to identify their components and see how those components change over time and across jurisdictions. And in this process, we use explicit protocols and rigorous quality control methods that are all documented so that our research can then be used for scientific evaluation. So in short, we take the text of laws and turn it into data that can then be used for evaluation and comparison to outcome data. And we don't just capture whether there's a law or there isn't a law, but we also measure the most important specific provisions and see how they vary across jurisdictions and change over time. So this is a snapshot. This is a snapshot of the policy surveillance process. It involves several steps, which you can see on the slide, and these steps are iterative and may be revisited throughout the process. But generally, we start by defining the scope and conducting background research to get a sense of the legal landscape on the topic. We then create questions to capture the key elements of the laws. Then we collect the text of the law and use that to answer the coding questions that we've developed for each jurisdiction. And the result is a legal data set that is published and identifies the key features of the law in a question and answer format, along with the legal text, a map, and legal data that is downloadable in Excel. And it's important to note that quality control is very important and pervades throughout this entire process in order to ensure that the data created by policy surveillance is accurate. And so all of the steps from research to coding all feature quality control measures. So why use policy surveillance? This process and its end result, which is empirical legal mapping data, plays an important role in improving population health. So policy surveillance is important because it fills a need for accessible, nonpartisan information about the status and trends in law and policy. And it uses a sort of just the facts approach that focuses on observation of the law rather than interpretation. And this approach can help policymakers to make better decisions. Policy surveillance also creates reliable data that can be used for evaluation. We really can't measure the impacts of laws and policies on health and health equity without data that details what's in the laws in a nuanced way, more than just the sort of binary, is there a law or isn't there, which often doesn't tell us much about how the laws are actually working on the ground. And the greater availability of reliable data can potentially speed evaluation of important policies. Another important aspect of policy surveillance is that it tracks change over time to measure progress. And this can be especially important with advocacy efforts. So policy surveillance tells us, are we making a difference? Are we seeing movement? If there is movement, what does it look like? So advocacy groups can track the progress of campaigns and efforts to change laws and determine where to focus efforts and resources. Also, policymakers can see what elements of laws have the most movement in other states. And government agencies can use this as a metric for the success of larger programs. In addition, policy surveillance also supports the diffusion of innovative policy ideas. So particularly through data visualization, like maps, we are able to clearly articulate in plain language the content of laws and policies. And through this, policymakers and legislators can easily see and compare their jurisdictions to others to hunt for good ideas and identify where they stand in the pack. And finally, policy surveillance is important because it supports the opportunity to build workforce capacity. The question and answer format of policy surveillance is great for non-legal audiences, and knowing the policy terrain really helps health professionals measure progress and plan initiatives. So here's a screenshot on this slide of where you can find all of our data sets. This is the topics page of the Law Atlas website. So lawatlas.org is a central place for sharing and accessing legal data sets on a variety of public health topics, as well as related resources on policy surveillance. So the data sets that you see circled here on the slide are our 3 housing-related data sets that we have published: the city nuisance property ordinances, state fair housing protections, and state landlord-tenant protections. And stay tuned for our next housing data set, which will be on city eviction laws, and we hope to publish that in the fall. So now I want to talk about some of the details of these data sets and how some of the laws they capture relate to domestic violence. Okay, so Sasha just presented some really important material on nuisance ordinances. And as a reminder, these ordinances generally require landlords to regulate the conduct of their tenants and penalize them when they fail to do so. And these laws, as we've heard, which may force tenants to choose between calling the police in an emergency or being threatened with eviction, these can have a disproportionate effect on domestic violence survivors and people with disabilities, who might have to call the police for help more often than others. So our data set identifies key features of these ordinances across the 40 most populous cities in the United States that were in effect as of August 1st, 2017. And just to give you some idea of the scope of our data set, I wanted to go over what types of ordinances we included and those that we did not. So we included in our data set ordinances that prohibit conduct that occurs at a residential property. We included ordinances that prohibit criminal activity at a residential property, where those ordinances were within the Nuisance Chapter of the city's code. And we also included ordinances that prohibit criminal activity at a residential property and regulate that activity in a manner similar to nuisance activity. Now, these ordinances may or may not explicitly use the term nuisance, and they may or may not specifically refer to a residential property. But as long as the ordinance did not explicitly refer to a commercial property, we included those. And we were really focused on capturing nuisance ordinances that regulate conduct. So we excluded ordinances that regulate only physical aspects of the property, so things like weeds, trash, water, unsafe construction, those were excluded. We also excluded ordinances that regulate only noise, odors, fumes, lead hazards, possession of animals, those types of things. We also excluded ordinances that regulate only vacant buildings, boarding homes, group homes, or housing for students. And we also excluded nuisances that were defined generally as anything considered to be a public nuisance under common law. As you can see from the slide, we found that 37 of the 40 most populous U.S. cities had nuisance property ordinances as of August 2017. And in case you're having trouble reading the map, Austin, Texas, El Paso, Texas, and Memphis, Tennessee were the 3 cities that did not have these ordinances. And so Sasha also covered the connection between nuisance ordinances and eviction in his presentation. And what we found in our data set was that 20 of the cities we studied explicitly include eviction of tenants as a possible means to abate a nuisance. So we've heard earlier that many nuisance ordinances define nuisance as a certain number of calls to police. So in the cities that we studied, Albuquerque, Boston, Chicago, Fresno, and Milwaukee all explicitly included certain types of calls for emergency services as nuisances. And in our data set, just to give you an idea of some of the language that these ordinances used, we coded calls for emergency service whenever the law referred to a specific call to a law enforcement agency, or if the law referred to a response from police for nuisance activities. We coded this when the law indicated that any call for emergency service was considered a nuisance activity, or if calls for emergency services regarding only certain types of conduct. For example, disorderly conduct, domestic altercations, when those types of calls were considered nuisance activities. 28 cities of those that we studied classified a disturbance as a nuisance, and the language in the law may not have used that term exactly, but we coded disturbance when the law referred to disturbing the enjoyment of public or private property, disturbing the peace, breach of peace, disorderly conduct, interfering with the reasonable use and enjoyment of a property, noise disturbance. So some of this language is similar to the language that Sasha pointed out in his case studies, and as you can see, it's really broad language that could encompass all kinds of conduct. And then 6 cities that we studied explicitly exempt domestic violence-related incidents. And related to exemptions, I just want to note that in 30 of the 40 cities that we studied, no conduct was exempt from being deemed a nuisance. Okay, now I want to talk for just a few minutes about another of our housing data sets, our state landlord-tenant protections. So landlord-tenant laws generally lay out basic rights and responsibilities for both landlords and tenants when renting residential property. And these laws govern lease agreements, maximum security deposit amounts, property maintenance requirements, steps tenants and landlords can take if agreements are broken, and other elements as well. So all 51 jurisdictions in the United States have a state-level landlord-tenant law, and our data set identifies the key features of those laws across all 50 states and D.C. that were in effect as of August 1st, 2017. As for the inclusion and exclusion criteria for this data set, we included landlord's duties regarding maintenance, tenant duties regarding maintenance, landlord remedies, remedies that are available to tenants, the maximum amount a landlord can charge for a security deposit, anti-retaliation provisions, and the tenant's ability to alter a lease when they are victims of domestic abuse, among other elements that were included also. So what did we not include? We excluded any rights or duties that might exist in common law but are not codified in the state law. We also excluded landlord-tenant laws governing commercial property and laws that apply only to mobile homes and floating homes. So as you can see from the slide, one of our findings that relates to domestic violence is that the state law in 15 states and D.C. allows domestic violence survivors to request a lock change. We also found that 24 states and D.C. have a state law allowing a domestic violence survivor to end their lease early. And just to sort of think about that in connection with the previous slide, there are 12 states and D.C. that allow domestic violence survivors to both terminate their lease and request a lock change. Our third housing-related data set addresses state fair housing protections. So most states have adopted their own fair housing laws to expand on the protections that are provided by the Federal Fair Housing Act, which is a law that prohibits discrimination in housing-related transactions for people who are members of a particular protected class. The protected classes at the federal level include race, color, national origin, religion, sex, familial status, and disability. And many states include additional protected classes in their state fair housing laws. They may include protections based on source of income, sexual orientation, or being a domestic violence survivor. In addition to establishing protected classes, these state laws regulate the types of discriminatory actions that are prohibited. So, for example, discriminations in the sale or rental of housing, discriminatory advertising, false statements that are made about the availability of housing, or refusal to lend money for housing. And these laws also address circumstances when discrimination is exempt under the law. So our data set identifies the key features of these laws across all 50 states and D.C., also in effect as of August 1st, 2017. Okay, and I just wanted to go over briefly the inclusion and exclusion criteria for this data set. So for our state fair housing data set, we included state fair housing laws that broadly prohibit discrimination in any real estate-related transaction, as well as laws prohibiting discrimination in matters of financial assistance. And for our exclusion criteria, the data set excludes remedies that are available to people who are discriminated against. We also did not include penalties that are established by the Federal Fair Housing Act or real estate discrimination laws that only apply to public housing were excluded as well. So as you can see from this slide, Mississippi is the only state currently that does not have its own fair housing law. And Illinois, Rhode Island, Wisconsin, and D.C. include domestic violence survivors as a protected class in their state-level fair housing laws. And we know that there are laws in other states that provide housing protections for victims of domestic violence. But this data set specifically tracks fair housing laws, so protections for domestic violence survivors appear in our data set only when included in a state fair housing law that explicitly includes survivors as a protected class and provides all of the protections and remedies that someone would have if they were discriminated against because of race, color, religion, disability, etc. Okay, so to put this all together and see what we learned from these data sets about housing law that may impact domestic violence survivors, again, 37 of the 40 most populous cities have a nuisance property ordinance. In most of these cities, nuisance categories are very broad and could easily include a tenant experiencing domestic violence, with 5 of those cities specifically referring to calls for emergency service in their nuisance ordinances. And then only 6 cities explicitly exempt domestic violence-related incidents from being considered a nuisance. So 20 of the cities that we studied are in states where domestic violence survivors may change their locks. 29 of those cities are in states where survivors may terminate their lease early. And only 3 of the cities are in states where domestic violence is a protected class under the state fair housing law. And it's important to note that these 3 data sets that I've discussed cover, particular areas of housing law. And there are, as I mentioned, there are other laws out there that provide housing protections for domestic violence survivors. And one example in Pennsylvania, since that's where we are, so there's a state law that prohibits the enforcement of any municipal ordinance that penalizes contact made for emergency assistance, either by or on behalf of a victim of abuse, a victim of crime, or anyone in an emergency. And there can also be local laws that provide protections. So this is not an exhaustive review of housing laws that may impact domestic violence survivors, but hopefully provides a sense of some of the gaps that exist in legal protections for survivors. And that is it for me, so thank you very much, and I will pass it over to Rasheeda.
Hi, everybody. My name is Rasheeda Phillips, so I'm going to cover a couple things. I'm going to talk about the Federal Violence Against Women Act, also known as VAWA. I'm going to talk about a few local protections, local to Philadelphia and Pennsylvania, in regards to housing and domestic violence. And then Les just going to cover a couple of advocacy tips based on some of the work we've been able to do in Philadelphia around this issue. So first, just to talk about the Federal Violence Against Women Act. That will be around 2005. It was most recently reauthorized in 2013. So I'm going to be talking about the 2013 version of the law. A bill has been put out to reauthorize it for 2018, and there may be some changes within that, but I'm going to talk about what currently exists. So I apologize for forgetting to add this to the slide. And let me put it on the slide. I apologize for forgetting to add this to the slide. The legal authorities that govern the Violence Against Women Act is 42 U.S.C. 14043E-11, and then 75 Federal Register 66246, and then finally HUD Notice number FR 5720N01, and I'm happy to give those citations afterwards. So what type of housing is covered under VAWA? So VAWA essentially covers all federally subsidized housing programs administered by HUD, USDA, and the Treasury. And so that's going to include programs such as public housing, Section 8 vouchers and project-based Section 8, USDA rural housing properties, low-income housing tax credit properties, and then a bunch of other programs that fall under HUD or fall under USDA or one of those other entities. So VAWA is it covers all of those programs. In terms of who VAWA protects, it's going to protect victims of domestic violence, dating violence, stalking, and sexual assault. So actually some of those categories were not originally available as part of it, but in 2013 they started to reauthorize the category of sexual assault. It also covers tenants, immediate family members, and other lawful household members. So again, the 2000 reauthorization actually expanded the protections to cover household members, and it does not have to be related by blood or marriage to the survivor. So anybody in the household who's a lawful household member. And again, it's covering people who are living in and seeking admission to one of the covered housing programs. So it's not just going to cover people who are already a part of the program, already living in subsidized housing, but it's also going to cover people who are applying to the program. And I'll talk a little bit more about what that looks like. So who must comply with VAWA? Obviously all of the kind of entities running the programs that I named previously, but in general that's going to be your public housing agencies administering the federal subsidized housing programs. So that's usually in the form of your local housing authority. Here in Philadelphia, it's going to be the Philadelphia Housing Authority. But this also covers non-housing authority staff and members, so it's also going to cover landlord Section 8 vouchers, owners of properties who provide subsidized affordable housing, managers participating in federal subsidized housing programs. And so that's who must comply with it. And so generally speaking, a landlord, owner, manager, or public housing authority making a decision based on admissions cannot use the domestic violence status as a denial reason, and it can't, and all different sort of ways in which domestic violence plays out, whether it's your criminal record, your credit history, your past evictions, these cannot be used as reasons to deny you admission, and as I'll talk about later, you make an adverse decision, such as evicting a person or terminating them from the voucher program on the basis of domestic violence. So what forms of violence are protected? What does it cover? Both actual and threatened violence, and it's going to cover emotional, psychological, physical, sexual, dating violence, and stalking as well. So it covers all of the different ways that domestic violence shows up, and part of that, and just to note that a lot of that was put in there after advocacy from domestic violence advocates to look at, have the law acknowledge the different ways that domestic violence and intimate partner violence shows up. It's based on one or more incidents. It doesn't have to be a pattern. It doesn't have to be something that occurred 10 times over 10 years. It's based on one or more incidents. And then, again, what the law requires, it requires the housing authority or the entity landlord to give tenants notice about the protections. So that notice needs to be included in emissions documents and application documents, as well as attached to the lease to any important sort of contracts or policies that are included in the subsidized housing program. So how does this play out? So first I want to talk about emissions and eligibility. So again, what VAWA says is that your status as a victim or as a survivor is not an appropriate basis for denial of admission or denial of housing assistance. So this is, again, at the admissions point, someone's applying, and it requires the housing authority or the entity making the decision to do a little bit of research, perhaps, and to read more into what's happening. Because if a person doesn't assert their VAWA rights or doesn't sort of explain, that there's a domestic violence situation involved, it could be easy to take a criminal record or credit history or past evictions that are normally, criteria that a person is allowed to look at and make a decision based on that. But the connection has to be made between those things and a domestic violence incident. So there has to be a connection between the criminal record, the credit history, or the past evictions and domestic violence circumstances, and those reasons need to be put forth. Typically how this plays out, though, is that the person ends up getting denied, and then they have a right to appeal that decision, and then during an administrative hearing can explain the circumstances and can make the nexus between the domestic violence and the criteria upon which the denial is being based on. In addition, VAWA covers evictions and termination of assistance. So essentially it establishes this exception to the federal strike criminal activity rule where, again, the criminal activity directly relates to domestic violence. So this goes for Section 8. They cannot terminate their assistance. You can't snatch someone's voucher away. And PHA, public housing, cannot evict on the basis of criminal activity, again, when the nexus is made between the activity and the domestic violence or sexual assault or what have you. It also allows for lease bifurcation. So in the reauthorized VAWA, lease bifurcation was clarified. So it allows the victim or survivor to maintain tenancy in the unit or in the program while evicting or terminating the perpetrator or bifurcating the lease to put the perpetrator in another property. So how this typically can play out, as an example, is that you have two people on a lease agreement. The abuser is head of household. The survivor is another person on the lease agreement. Once the survivor establishes the VAWA protection, it is an option for the housing authority or the landlord to bifurcate or split lease. So that would mean qualifying the survivor to be the head of household and creating separate lease agreements and then transferring the abuser or whoever out of the unit and giving them two separate units. So that is an option under the VAWA law. If the remaining tenant can't establish eligibility, then the landlord is required to provide reasonable time to find new housing. So again, under the example that I just gave, if for some reason a survivor can't qualify as head of household for whatever reason, the housing authority or landlord is supposed to give a reasonable time to find housing. This can be tricky with a protection from abuse order. Just wanted to note that, particularly in Pennsylvania, under state laws, the protection from abuse order allows for an eviction process. So a person can claim eviction on the protection from abuse order, but how that will play practically with the VAWA protection and just with practicalities of getting people in safer housing or moving people out of an abuse situation. It can get tricky, especially timing-wise. And then also what VAWA allows is transfers and breaking of the lease agreement. So it allows, as I said, for a lease bifurcation. It allows you to port a voucher to another jurisdiction. So it creates typically when someone wants to port their voucher, there's a bunch of bureaucracy that they have to go through. They have to prove that they have a job. And I'm sorry, just to clarify, what porting a voucher means taking that voucher to another jurisdiction and finding housing in that jurisdiction outside of the housing authority that you're a part of. So if you're in Philadelphia, you want to port your voucher to Chester County, for example, there's a process, but it's a pretty onerous process in terms of what you have to establish before you can port. Under VAWA, domestic violence is a reason to allow for porting the voucher without the extra sort of bureaucracy around it. And then finally, what it allows for is emergency transfer. And one important thing that the VAWA 2013 law did was create a requirement for housing authorities to adopt a model transfer plan. So housing authorities should have an emergency model transfer plan in place that is specific to domestic violence survivors and sexual assault survivors, and not just a part of their normal sort of emergency transfer plan that's for things like, habitability issues in the home or other issues. So this is a kind of something that is specific to domestic violence survivors. And also allows for breaking lease with 30 days notice. So under VAWA, how do you go about doing this? How do you go about requesting this protection? Unfortunately, with the VAWA law, it's a self, you have to actually state that you're a domestic violence. So it's a self-identity sort of policy. Like you have to identify yourself as a survivor. You can't really put the onus so much on the other party to know that or to know, the nexus between these kind of other criteria issues and the domestic violence. So there's a number of different forms of documentation that are acceptable under VAWA. The first is a HUD Self Certification form. It's a 1 or 2 page form that just has the survivor talk about the last incident of abuse and has them identify a couple of other things on that form. So that form in and of itself is enough. So something that we heard a lot from our housing authority, and I know this to be an experience elsewhere, is that usually the housing authority is trying to require the person to submit something in addition to that self-certification form because there's discomfort with that form in and of itself being, having the power to do all of these things and provide all of these protections. However, that's a misconception. That's something that we advocated with HUD to clarify, that the HUD self-certification form in and of itself is enough. And any of these forms of documentation, one is enough. So you can turn in the HUD self-certification form, you can turn in documentation from a victim service provider, a medical or mental health professional, or an attorney under penalty of perjury. So what that's going to look like is writing a letter and, an attorney kind of putting in that language that under penalty of perjury, I'm asserting that this person is a survivor, I work with this person. Or a court, police, or administrative record, so that's going to be hospital records and things of that nature. So there is some time limits around this documentation. So again, just to give an example of how this might play out, someone in Philadelphia, we have an emergency transfer policy with the housing authority specific to domestic violence survivors. A person attempts to utilize that policy, and then the housing authority says, okay, well, you have to show proof. So a person can turn in this HUD self-certification form, and if the housing authority requires it, must provide it within 14 business days. But that time frame is discretional. So if discretionary. So if the housing authority said, okay, you can take 3 weeks, I understand how long it may take to get that documentation, that's allowable under the law, but if they require that 14 business days, you have to turn it in within that time. It's important to note that survivors can be evicted for lease violations unrelated to domestic violence or if their tenancy continues to pose a threat to the community. So, we us advocates know sort of the cycle of violence and how There are times when, a survivor may go back to the abuser or can't leave the situation immediately. And so unfortunately, under this law, it does allow still for a sort of termination of the tenancy if there continues to be a sort of a threat to the rest of the community. So, again, what that may look like is like if the person keeps going back, the housing is already being like, okay, well, she keeps going back and he keeps going back and this keeps happening, so we have the right to kind of look towards termination. But again, if you're an attorney working with a survivor, you do your due diligence to try to make that nexus between the violence and the sort of other circumstances that may be happening. And it may not look like, what we all think it's going to look like. So there is room for a little bit of creativity around making some of that nexus. It's not necessarily time-bound either. And then there's a huge confidentiality to this. Information must be kept confidential. You would think that that's, something that's obvious, but it's really not obvious, and it is something we often have to provide housing providers to make sure that this information is being kept confidential, especially if the abuser lives, in the complex or whatever the case may be. So that's it on VAWA. So I'm going to briefly talk about some local protections. And again, these are local to Philadelphia and Pennsylvania. These protections are regarding private housing. So because VAWA unfortunately does not cover private housing, it only, again, covers subsidized housing programs. So some of the things that we've been able to get locally under our court procedures, Pennsylvania allows an extended appeal filing deadline for survivors who are appealing adverse eviction decisions. So if someone's been evicted, they can get additional time to appeal, and they have to file a certification similar to the Hud Self Certification form stating that they're a survivor in order to get that extended deadline. There's a bunch of legislation pending in the state. So there's HB 1051. This would be a statewide lease termination provision that would allow for a survivor to sort of using the same kind of documentation under the VAWA law. If you turn in a letter or some type of documentation, medical record, things of that nature, you are empowered to terminate your lease agreement for your safeties, and it gives you a sort of time period by which to do that and which to move out from that situation without penalty. So that's pending. It's been pending for a couple of years, so we don't know what the movement of that is going to look like. And then we currently have a pending statewide bill, SB 919, and this will create a statewide emergency transfer policy that would allow for relocation of survivors in subsidized housing. So in a sense, what this legislation is hoping to do is to codify as a state law VAWA protections, because despite the fact that VAWA 2013 requires housing providers who have this emergency transfer policy in place is very uneven. So Philadelphia, we have one in place, but other parts of the state don't have one. So this will kind of codify that and make it a requirement as a part of the state and not just under the federal VAWA legislation. And then finally, we have a local ordinance in Philadelphia under our Fair Practices Ordinance and our Commission for Human Relations, Domestic Violence laws, and that's at 9-804, they're unfair rental practices. And essentially what this law allows is what I just talked about earlier, which is that it allows for early lease termination. And so how that shakes out is that, again, if a survivor submits documentation very similar to what's under VAWA, except the HUD certification form is not a part of that documentation. If they submit that to their landlord and write a letter, they can terminate their lease agreement within 30 days notice and move without penalty and not, have their security deposit kept or any other thing like that. So it allows for early lease termination. And in addition, what that law does is it protects DV survivors and sexual assault survivors from discrimination in housing. So what it says is that an incident of DV or sexual assault in which a tenant was a victim or a tenant's status as a victim of domestic violence or sexual assault is not cannot be grounds for an adverse decision or discrimination and things of that nature. So that's that protection. And finally, just wanted to go over a couple of housing advocacy tips that we found to be helpful and have been successful around locally. So requesting a domestic violence or sexual assault liaison at the local housing authority, it worked wonders to have someone whose responsibility it was and you know, who the point person for issues that would pop up around domestic violence and sexual assault and housing. So, for example, again, with the emergency transfer stuff, before there was a policy in place, the emergency transfer wait list for DV survivors was about over 100 people long, and it would take sometimes years to get people transferred just because of the low housing stock. But with our advocacy and putting a policy in place and requesting that they have a DV liaison, we was able to get that list down to generally it's about 20 people on the list, and they move within 3 months usually, or able to get transferred within about 3 months. And also created a process where survivors can transfer from one program to the other if it's kind of reached a last resort. So if you're in a public housing program and they can't find you housing to transfer into, giving you a voucher, qualifying you for a voucher instead so that you can have the market. And then advocating for emergency transfer policies if you don't have it in place yet, and making sure that that policy is realistic to the circumstances that survivors are actually going through in your area. As you already heard about, challenging noise and disturbance ordinances, using the Fair Housing Act you heard about earlier, and then using partnerships with other DV and sexual assault organizations and legal services organizations to cover needs across a wide range of areas. So one of the things that we were able to do in Philadelphia was we were able to get a grant from the Department of Justice, and we Community Legal Services, Women Organized Against Rape, HIAS, which is an immigration organization, and Self-Deal Legal Assistance, which provides a lot of family custody assistance. We were able to form a hotline that people could call and get on the bus so that they don't have to go around to 5 different places to kind of deal with some of the issues that are inevitably popping up as a part of their circumstances. So we've found that program to be really successful, and we've also gotten some other funding to help us identify sexual assault survivors and prioritize their cases so that we can provide them with assistance. And then finally, advocating for shelter, emergency, and transitional housing programs that are specific to survivors. So that's it for me. Thank you.
All right. Well, I want to say thank you to all of our panelists for their presentations today. There's a lot of great information that was shared with the group. I think a lot to take in, but before we go into our question and answer session, I wanted to just bring up 2 key points. The Network for Public Health Law has done some research and work in the area of housing rights of DV survivors, and we've created some resources that you can access on our website, and just on this slide we have a couple of those resources highlighted. Also, the Network for Public Health Law does technical assistance, so if you have specific questions that come up in your work where you want to learn more about different policy approaches or what the policy approach is in your specific jurisdiction, beyond some of the issues that were brought up today, we're here to do that type of legal research and technical assistance for folks. So don't hesitate to reach out to the network in this area or any other public health issue. But that was just one last plug before we go into the question and answer session. Now, a couple of questions came in that I want to direct to folks, and I will hopefully hand over the microphone appropriately. But the first question was for Sasha. One of the participants was interested in the the maps you had on discriminatory policing and enforcement as it related to Peoria, Illinois, and was wondering where you got that data from. It was your GIS maps. So if you could just address that, Sasha, and let folks know where you got that data, and if they were also interested in what software you used to generate those maps. But if that's just something you sourced from elsewhere, that's great too.
Okay, do I have control of this?
Believe so.
What I was going to do. Okay, so it sounds like you can hear me. I was going to go back, but I guess I don't have to go back to put the map on the screen as I discuss this. The answer to your second question, unfortunately, is I don't know. We go back and forth between different software packages all the time, and I actually don't know what we're using right now. But to address the first question, the source of this was public records requests that we made to the city of Peoria, and we asked them for each incident of nuisance enforcement. And what we got back several hundred incidents, and each one was had the address of the building in question. So based on that, we had our people code the address of each of the enforcement actions, and that's what we plugged into the mapping software to produce the map that you saw. And then we have we were able to get at the local level the demographic information you see just comes with the mapping software, so we can overlay that.
Great. Another general question just popped in, and I can answer this one. There was a question of whether or not the slides from all three of the presentations will be made available for folks, and the network will have the slideshow from this presentation as well as the audio from the webinar posted on our website for people to reference at a later time. So that's an easy one I could answer. A question for Katie. Looking at the policy surveillance you did, why did you choose to look at nuisance property ordinances at the city level when your other two data sets were looking at tracking law at the state level?
So great question. So the nuisance properties are mostly regulated by local municipal ordinances. So there are some states that regulate nuisance properties, but really mostly it's done at the local level. So we thought looking at the 40 most populous cities in the United States would provide a good sense of what these ordinances look like in various parts of the country, and allow us to track those ordinances that are affecting a large number of people.
Great. Sasha, another question for you. Why are communities enacting these nuisance ordinances and enforcing them in this way against folks?
Well, we have heard two basic justifications from them. One is a sort of generic tough on crime, and that's what we've heard in, for example, Peoria. Peoria just says it has a crime problem, it says, and this is the way to address that crime problem, is to sort of push some of the onus for enforcement onto landlords. And in theory, this is supposed to make landlords take responsibility for the quote-unquote criminal element in their properties. Now, I've seen no evidence that this actually works to address that, but that's their stated concern, is that this is part of a sort of tough-on-crime policy. The second reason that we hear, and I think what we saw at Maplewood is more of an example of this, is a stated concern that certain people are draining municipal resources because they need help, and because they're constantly calling for help, and that could be people with mental illness in addition to people with domestic violence concerns. And here we have a very sort of backwards way of looking at it, in which what they're saying is there are people who are repeatedly seeking the same assistance and nothing ever changes. A woman calls for help, we respond, and then 2 weeks later she calls for help again because she's suffering abuse again from the same man. If we don't penalize her in some way, we're just going to keep going through this cycle, and they're frustrated with that cycle. They don't want to continually show up at her door every few weeks because of the domestic violence. You could certainly, I guess, have some sympathy for the issue, but obviously it's a very ham-handed way of addressing it. But that is the second stated concern that we're hearing a lot is this drain on municipal resources for sort of frequent flyers, people who are constantly calling the police.
Now, in response to the enforcement of these policies, what can communities do to try to address the problems that these public nuisance ordinances are creating?
So we would say that this is coming at it from the wrong direction. What communities should do is they should think about what is their legitimate interest, and then how do they want to achieve it. In some ways, the nuisance ordinances are backhand ways of doing something that if you stated them as your policy, it would clearly be something that the community would not accept. For example, if you stated as your policy, a woman may not call for help when she's suffering domestic violence, I think it would be obviously objectionable. But because you do it in this backhand way, instead for penalizing her, that's how it seems somehow better. But instead, I think that what they should do is they should actually think, what behavior do we want to incentivize? What do we want her to do? And then try to enact policies that actually make that happen.
Excellent. We have about 5 minutes left, and what I just want to run down the panel and see if there is kind of a call to action that, or maybe not a call to action, but if individuals are concerned about these issues, what is, we had some very specific advice by Rasheeda in her presentation, but are there additional things that people who are concerned about these issues can do to make an impact in their community? Are there ways that they can get involved or educate themselves to be part of the solution? I know, one of the things that jumps out at me is when we're looking at these local nuisance ordinances, is there, a state policy intervention that could preempt some of these kind of discriminatory and hurtful policies? And I believe there are a few states that have some protections in terms of, preventing landlords from penalizing tenants who are survivors of domestic violence for these type of incidents. But, that would be something that, I think folks should look into because, preemption can be a helpful tool. It can also be a barrier at times for public health. But I was wondering what other folks on the panel kind of had as, things to put on people's radar or next steps, so to speak.
So this is Sasha. What I would really encourage is not so much steps to fix the law on paper, although that's helpful when you can get municipalities or the states to pass laws saying you can't do this based on domestic violence. I think there needs to be more information publicly made available. I would love to see people pass laws either locally or at the statewide level that require that some form of information be made public automatically regarding how these ordinances are being enforced. Obviously you need to protect people's sensitive personal information, But really, it turned out to be shocking to people in Maplewood, and this is a community of only 10,000 people, right? This is a little town. It was shocking to them what was being done in their name. They just don't know. So until someone makes an open records request, this is just these discriminatory acts are being hidden in plain sight. So I would encourage either people make open records requests and get the information, start building that information out, or try to make that information publicly available as a matter of course in some fashion.
Interesting. Excellent. Katie or Rasheeda, is there anything you'd like to add?
This is Rasheeda.
No, go ahead, Rasheeda.
Yeah, so I was just going to add pretty much what I said before, that I think it's really important that, I'm assuming that this is mostly attorneys on this webinar, but it's important that we not sort of silo ourselves from each other and from other advocates and other organizations who can approach this thing from a different perspective. So I think a lot of our work has been successful because we've partnered with agencies like Women Against Abuse. If we hadn't had them at the table, there would not be as robust a emergency transfer policy as there is at Philadelphia Housing Authority. We're working with them now to create a safety plan for survivors that includes housing. So it's really important, and there's lots of different parties. That's important that we not silo ourselves and that we sort of approach this from a holistic perspective in order to increase protections for DV survivors and sexual assault survivors. So that's my plug, but I have lots of other ideas and some of the that I talked about on the PowerPoint.
Excellent. Yeah, partnerships I think are key in this public health challenge, and any public health challenge is kind of stepping outside the silos and working with folks across sectors to address these problems and challenges. Katie?
Yeah, I just wanted to mention, just thinking in terms of, amendments or changes to these nuisance ordinances that, may ameliorate the impact that they're having on domestic violence survivors and other people who are, seeking emergency assistance. As I mentioned in my presentation, there were 6 of the cities that we studied that explicitly excluded domestic violence incidents, which is, I think definitely a step in the right direction. But also I think to sort of, for, folks out there who are thinking about amending these ordinances to even broaden those exemptions to include, all victims of crime, all people who are seeking emergency assistance would be really useful as well.
That's an excellent point. Well, I want to thank the panelists again. Thank you very much for sharing all this important information with our audience. It looks like we have reached the end of our webinar today, and I also want to thank everyone who attended, and hopefully this is a resource that is going to be helpful in your understanding and your efforts to address this in your community. This recording, as I mentioned before, will be available on the network's website as well as the slides. And thank you very much. Enjoy the rest of your day.